about the history as well. So I want to ask all the participants the very basic question: what do you understand by contempt? The word contempt of court, so that I can have an idea how much you know. Anyone? No. I think students are from LLB. I believe you all know what is contempt. The very basic meaning of the term contempt literally means disobedience or any disregard, neglect, or violate. That is contempt. Now we are talking about contempt of court. So the person who commits the contempt called as contemner, and the expression contempt of court means that willful disobedience, disregard towards the court, or let's say the authority of the court. So many jurists basically try to define what is contempt of court, though there is no proper definition, but yes, they have tried. If you have to consider the first definition, Sir William Blackstone, he tried to define the contempt of court is the disobedience to the rules, orders, or process of court, or against the king's prerogative. So the key words from this definition is disobedience. किस बात का disobedience? Rules, orders, जो court के processes है regarding that. Then the next definition we can talk about, it is about abort. Contempt of court is a disobedience or interruption of the orders of proceeding of court or legislative body. Even abort के definition में the key word यहाँ पे we can see is disobedience. And then Burrell's definition, contempt of court is disobedience or disregard of authority of court. So we can see all these definitions. All these definitions talk about disobedience. So I'll just revise quickly. Contempt, इसका literal meaning, dictionary meaning है disobedience, disregard, neglect. And now that we are talking about contempt of court, कोर्ट का कोई भी ऑर्डर है, प्रोसेस है, रूल्स आर laid down by the court, and if one person is sheerly showing the disobedience about it, that will amount to contempt of court. Before we actually move to the Contempt of Court Act, I would just give you a short idea about the history कि contempt of court क्या था, कहाँ से आया, उसका background, whether it was from British rules. Let's discuss that. The history of law of contempt in India can be traced back to both indigenous legal traditions and colonial influences. And latest अगर देखा जाए तो है सन्याल कमेटी का रिपोर्ट. Ancient India perspective एक बार देख लेते हैं. India had traditional mechanism to protect judicial and administrative institutions even before the formal codification of contempt laws. The ancient legal scholars like Kautilya, you must have heard, in his Kautilya's Arthashastra, highlighted the importance of respecting the authority. Basically, he stated, any person who exposes the king, insults his council, or makes any attempt to undermine the king should have his tongue cut off. Matlab, you cannot just disrespect the king or insult his council. Or he also emphasized judicial discipline by stating that when a judge threatens, bullies, or silences any disputants in court, he should be punished. So judicial discipline has also been advised in Kautilya's Arthashastra. Then we can move, once we are done with this ancient idea, let's discuss what was British influence. During the British colonial period, Indian legal system adopted several English laws, including the concept of contempt of court. However, contempt law in India did not fully mirror English laws, but incorporated distinct Indian elements. अगर contempt of court अभी जो हम act पढ़ रहे हैं, that is 1971. If we have to check the history, we have 1926 act, we have 1952 act. Of course, there were loopholes. Of course, there were something which was not apt, and then hence we needed amendments. 1926 का जो act था, that is Contempt of Court Act 1926, first statutory provision on contempt was enacted there, and it applied only to high courts and their subordinate courts in certain provinces such as Rajasthan, Saurashtra. Then Contempt of Court Act 1952 जो था, there was no uniform statutory provision for contempt of court. This act extended to whole of India except Jammu and Kashmir and granted high courts to authority to punish contempt of subordinate court. However, in both the acts, contempt है क्या किसी ने define ही नहीं किया था. And that's why we talked about all the jurist के definition. And there was this major need कि reform रहे, क्या है contempt, कैसे identify करें, how we are supposed to punish. So Sanyal committee came into the picture. Despite earlier legislation, the legal framework on contempt remained unclear, especially concerning the balance between contempt law and fundamental rights. We talk about contempt when it comes to fundamental rights such as Article 19(1)(a), Article 21. So there was this conflict which already there. And recognizing this issue, a bill was introduced in the Lok Sabha on 1st April 1960 by Shri B.B. Das Gupta. And he was basically, that bill was seeking to strengthen and clarify the law on contempt. The government, after reviewing the bill, identified the need of comprehensive reform and appointed a special committee under the chairmanship of H.N. Sanyal. And Sanyal committee submitted its report and addressed the gap, and finally we have the Contempt of Court Act 1971. So the major necessity of Contempt of Court Act 1971 was कि किसी ने contempt क्या है define ही नहीं किया था. And now let's move to the 1971 Act, जहाँ पे if we go through section 2. Section 2 basically talks about what is contempt. It provides that contempt of court means civil contempt or criminal contempt. Section 2B of the Act provides civil contempt. Civil contempt, यहाँ पे if you can see, it means willful disobedience to any judgment, decree, direction, order, writ, or other processes of court, or willful breach of an undertaking given to a court. So two things we can talk about यहाँ पे. एक है willful disobedience and second है willful breach. ये disobedience किस बात का है? It is towards the judgment, decree, direction, order, writ, or any process. And breach, suppose you are submitting some affidavit, you are submitting some undertaking, and you are not following that. That is a willful breach. This will amount to civil contempt. Whereas section 2C defines criminal contempt. Criminal contempt means publication, whether by words spoken or written, or by signs, or by visible representation or otherwise, of any matter or the doing of any other act whatsoever which. And there are three things which we can talk. That is the scandalizes or tends to scandalize, then lowers or tends to lower the authority of the court, then prejudices or interferes and tends to interfere with the due course of any judicial proceedings, or interferes and tends to interfere, obstructs or tends to obstruct administration of justice. If you want to remember this thing easily, some keywords for you. क्या हो रहा है यहाँ पे? बेसिकली स्कैंडलाइज हो रहा है या टेंडेंसी है स्कैंडलाइज करने की. कोर्ट की अथॉरिटी लोअर हो रही है या टेंडेंसी है लोअर हो सकती है. So authority of court is in the danger. Then second thing, that is prejudices or interferes with the due process of any judicial authority. And third, administration of justice. So if we can see keywords, authority of the court, any judicial proceeding, due course of any judicial proceeding, and third, administration of justice. इन तीनों चीजों में अगर कोई डिस्टर्बेंस, इंटरफेरेंस, स्कैंडलाइजिंग, लोअरिंग द अथॉरिटी, ये सब हो रहा है तो वी आर गोइंग टू कॉल इट क्रिमिनल कंटेम्प्ट. See, basically this definition which we are seeing in section 2, this is not definition. We can see there is just classification कि civil contempt है, criminal contempt है. And moreover, the contempt of court cannot be defined exhaustively, and it is thus better to leave it to the court to deal with the each case. अगर एक बार हमने define कर ही दिया तो people will stick to that bracket and they will find mischief and commit the contempt, because it is again a willful disobedience. Willfully you are scandalizing or lowering the authority. So hence it is left to the courts to decide whether this is contempt or not. If we have to talk about these civil contempt, what is civil contempt, criminal contempt, we have seen the definitions. We have also seen what is section 2D says, that high court means high court for the state union, because it was important to define considering the previous acts. So let's move to the next part, that is, now that you understand what is contempt, there are chances contempt कहाँ कैसे कैसे हो सकता है. Contempt lawyers से हो सकता है, contempt judges से हो सकता है, corporate bodies, and the basic contempt jurisdiction also. कंटेम्प्ट जुरिस्डिक्शन पहले देखते हैं. अगर कंटेम्प्ट जुरिस्डिक्शन डिस्कस करना है, सो आर्टिकल 129 एंड आर्टिकल 215 ऑफ इंडियन कॉन्स्टिट्यूशन डिक्लेयर द सुप्रीम कोर्ट एंड हाई कोर्ट, they are court of record, and that's why they, being the court of record, have inherent power to punish the contempt of court, and this power cannot be taken away from any legislative through any legislative power. Court of record क्या है? Court of record has been defined by so many through so many dictionaries. Corpus juris secundum में एक definition है that says that where the acts and judicial proceedings are enrolled in parchment for a perpetual memory. For example, court of record is something which keeps all the records. The court which is bound to keep all records of all the proceedings, that is basically, and it has the perpetual memory, that is court of record. So High Court and Supreme Court court of record है. 129 and 215 gives High Court and Supreme Court to punish for contempt jurisdiction. Does that mean lower courts के पास power नहीं है? Constitutionally देखा जाए तो नहीं है. But according to section 11 of the act, a High Court shall have jurisdiction to inquire or try into the contempt of itself of any subordinate court. अगर High Court में हो रहा है contempt, High Court will take cognizance. Supreme Court में हो रहा है, Supreme Court will take cognizance. But अगर किसी subordinate court में हो रहा है, तो that High Court will take the cognizance of that contempt. Every High Court, section 10 also says that every High Court shall have the exercise the same jurisdiction and powers and authority in accordance with the same procedure and practice in respect of contempt of court subordinate to it. And so section 10 and 11 basically empowers the High Court. Later we can talk about the appellate jurisdiction. For appellate jurisdiction we can refer section 19. Section 19 basically says that an appeal shall lie as a right from any order or decision of High Court in the exercise of its jurisdiction to punish the contempt. Where the order or decision is that a single judge, suppose the order is given by a single judge, appeal कहाँ पे जाएगा? To a bench not less than 2 judges. And जहाँ पे order already bench ने दिया हुआ है, then appeal will go to Supreme Court. Then power of Supreme Court and High Court to make rules. According to section 23 of the Act, the Supreme Court, as the case may be, a High Court may make rules not inconsistent with the provisions of this Act, providing for any matter relating to its procedure. Agar Supreme Court and High Court, so do we see any procedural part? No. So this basically section 23 gives Supreme Court and High Court to make the rules, to make the procedural part. They can make the rules not inconsistent with the Contempt of Court Act. And then we must talk about contempt jurisdiction of subordinate court. High Court and Supreme Court के clearly laid down है कि they have contempt jurisdiction. But what happens when subordinate court में contempt हो रहा है? In this case, the contempt.
Sorry to interrupt. The PPT is not visible.
It's not visible.
No, ma'am.
Just check. I'll just try again to share the PPT. Just let me know if it is visible now.
Yes, ma'am. Now it is visible.
Thank you so much for notifying. So yes, we were talking about appeal, right? So contempt jurisdiction for the subordinate courts. So in the case of contempt committed in the face of subordinate court, section 228 of IPC basically dealt with these provisions. Section 228, 344, 346 of CRPC. Section 345 of CRPC lays down the procedure and investigation and punishment for the offences specified under section 175, 178, 179, 180, 228. 175 क्या है? तो 175 of the Indian Penal Code deals with the omission to produce document. to a public servant by a person who is legally bound to produce it. It provides that whoever being legally bound to produce or deliver up any document to any public servant, such as intentionally quits to produce and deliver up the same, shall be punished with simple imprisonment. So you can see the disobedience wala. Just give me a minute. I'm not able to. Yes. So 175 basically talks about disobedience only, and if anyone is not able to produce any document, any deliver up the same, then that person shall be punished. If we are talking about the contempt by lawyers, judges, corporate bodies, and what are the instances कि lawyer कब contempt commit कर सकता है? So lawyers being the officers of the court, they contest the cases in the court for and on behalf of the litigants. Thus, on account of the nature of duties discharged by the lawyers and judges, they may get into heated dialogues. Lawyers and judges, the conflict you all have must heard about it. There are several cases of misconduct which have concluded establishing contempt of court against advocates. There was this one case that Re Ajay Kumar Pandey case, जहाँ पे the Supreme Court has held that advocate using intemperate language, casting unwarranted aspersions on various judicial officers and attributing motives to them while discharging their judicial functions would be held guilty. So बहुत बार ऐसे होता है कि in the moment of heat we express our dissatisfaction or we pass some comments that yes, judge is very biased. This all things will amount to contempt by advocates. What could be the instances कि advocate कब contempt commit कर रहे हैं? Advocate using foul language or communication with the judge by advocate amounts to contempt only when it interferes with the administration of justice. Suppose chambers में जाके you are discussing the existing case, that will amount to contempt. Even comment by an advocate stating that common man in the state has lost the confidence, अभी लोगों को विश्वास ही नहीं है, faith ही नहीं है, that will amount to contempt. Private communication of suppose you are submitting or sending a letter to the judge thanking for the judgment, that will amount to contempt. Publication of pamphlets making derogatory statement about during the election and making statements remark about courts, criticizing the methods adopted by judges. Even there have been instances, if you have watched Mamla Legal है, that one Netflix series, you must have seen certain instances की जो contempt होता है, judge paying फेंकना or hurling shoes, making false endorsement, all these things will amount to contempt by advocates. Then the next category which we can discuss is that contempt by judges, magistrate. अभी judge ही contempt commit कर सकता है क्या? So to answer to that question, according to section 16, Contempt of Court Act 1971, a judge, magistrate, or other person acting judicially shall also be liable for contempt of court on his own court or any other court in the same manner, or any other person is liable for the provisions of this act. So if what are the instances कि जब कैसे बोल सकते कि judge has committed contempt? Suppose एक judge, if the judge used indecorous words or indulges in unseemly and indecent language, then the impressional concept of seat of justice will get ruined. So that will amount to contempt. So judge should be extremely careful about the language, about the selection of words which they are using while sitting in the courtroom. Suppose if the inferior or subordinate court does not follow the law laid down by superior court, high court का कोई तो order है, subordinate court is not following, or suppose high court has given some instruction to subordinate court, that will amount to contempt. A judge of subordinate court is held liable in contempt for disobeying the orders of high court in many instances. Even the criminal contempt भी कब हो सकता है? Judge may be held liable for criminal contempt if his acts, conduct amounts to scandalizing or lowering the authority of the court with the due course of any judicial proceedings or interference with the administration of justice. There was this one very popular case that has basically declared that judge of High Court was guilty of contempt. So there are alleged instances जहाँ पे judges are also liable for contempt. The next category which we can discuss यहाँ पे, that is contempt by state and corporate bodies. So at present in India, state is not immune from contempt liability. So they can be considered liable. For example, if an injunction or order is passed against the state or corporate body and it is found that there has been willful disobedience on the part of state or corporate body, the officer will, for its implementation, will be liable. So are we going to call it state liable? No. The officer, whoever is representing that particular department, will be liable. Whoever is the person in charge of that subject matter will be liable. And then there are certain provisions that suppose any order is passed against an officer, his successor is also bound to obey that order. And if the successor is not following that, he will be liable for contempt. And when we talk about ministers, it may be pointed out that he may be liable for contempt in his personal capacity when he violates the law resulting into contempt. In his official capacity, ministers or chief ministers are held liable when they are party to the case for any willful disobedience of the court. So these are the instances जहाँ पे state bodies, corporate bodies, judges, magistrate, even lawyers are committing the contempt. We can now discuss the punishment part. I don't have the slide for the punishment part, but I'll just try to explain what is punishment. And for that, you can refer section 12 of Contempt of Court Act. So there are 5 clauses. First says, subsections 1 says that save as otherwise expressly provided in this act or in any other law, contempt of court may be punished with a simple imprisonment for a term which may extend to 6 months or a fine which may extend to 2000 rupees or both. So बहुत ही simple है. As per section 12, contempt of court के लिए punishment क्या है? 3 things. Simple imprisonment up to 6 months. Second, fine up to 2000. Third, both. And provided that the accused may be discharged or the punishment awarded may be remitted on apology. तो आपको अगर punishment दिया भी जा रहा है, you can get away with that if you are apologizing. But the only condition is that apology is being made to the satisfaction of the court. And court can totally reject your apology if court thinks that that has not been made through some genuine intention. Then the next is the subsection 2 says, notwithstanding anything contained in any law for the time being in force, no court shall impose sentence in excess than whatever has been specified in subsection 1 for any contempt, either in respect of itself or subordinate court. So ये जो 6 month का जो हमारा punishment है, that should not be exceeded. Then now we can talk about civil contempt and criminal contempt. तो दोनों के लिए punishment same है. But then subsection 3 एक थोड़ा सा twist यहाँ पे add कर रहा है, that is notwithstanding anything contained in this section where a person is found guilty of civil contempt, the court, if it considers that fine will not meet ends of justice, अगर court को लग रहा है ना that fine से नहीं justice मिल रहा है, क्योंकि लोग people will do this, they will commit the contempt, they will pay the fine. In that case, or the sentence of imprisonment is necessary, अगर ऐसे लग भी रहा है, तो civil prison का provision यहाँ पे it provides. So that is about the punishment part. And contempt of, and then section 12 अगर punishment के बारे में बात कर रहा है, तो section 13 says, according to section 13 of the Contempt of Court Act, notwithstanding anything contained in any law for the time being in force, no court shall impose a sentence under this act for contempt of court unless it is satisfied that the contempt of such nature that is substantially interferes or tends to substantially interfere with the due course of justice. Contempt of court का ना basic purpose ये नहीं है कि punishment ही देना है, fine ही देना है. उसका बहुत ही basic objective क्या है कि लोगों को बताए that they cannot just come randomly and speak things about court that will shake the very foundation and faith regarding the system. And after section 13, there is section 20 that says about that talks about limitation. So according to section 20, no court shall initiate any proceeding for contempt on its own motion or otherwise after the expiry of one period. So limitation period है for this one period from the date which the contempt is alleged to have been committed. सपोज अगर 1 मार्च को कंटेम्प्ट कमिट हो रहा है, the limitation period will be of 1 year. So on that line, I will move to our next slide, that is remedies. रेमेडीज क्या है, हमने देख लिया कंटेम्प्ट कैसे हो रहा है, कंटेम्प्ट के टाइप्स क्या है, कौन कौन कंटेम्प्ट कमिट कर सकता है. नाउ व्हाट आर द अवेलेबल रेमेडीज? वेरी बेसिक थिंग्स, apology and the second remedy is appeal. When we talk about apology, according to the provisions of section 12, contempt of court में बोला गया था that accused may be discharged or punishment awarded may be remitted on apology being made to the satisfaction of the court. अब ये satisfaction of the court is bringing or giving all the discretion to the courts. Court is not bound to accept the apology unless there is real feeling or repentance in the contemner. The contemner cannot be allowed to get away by simply feeling sorry by way of apology. मतलब मैंने contempt कर लिया, I am sorry, then again you are free to do it. So it should come from heart. It should not be just on paper. That is what court is trying to say. Contemner cannot be allowed to get away by simply feeling sorry by way of apology as the earliest way. The apology should not be tendered with the object to avoid punishment, but it should be a sincere and made in good faith with real feeling and repentance. And then let's talk about the acceptance of apology. Court के लिए factors क्या क्या हो सकते हैं? So factors like attitude of the contemner, gravity of contemptuous conduct, or his past record, all these things will be taken into consideration. Generally, apology is not accepted from those who are found to be indulged in repeated disobedience or from those who persist in justifying the action. Matlab, I'm sorry, but okay, this was the reason. When you put such conditional apology, court will think whether this is genuine or not. You can, for apology, Prashant Bhushan's case is very popular. You can go through that as well. Court considers that apology tendered in the court is not sufficient and may say that apology will be accepted only when it is made to the court before public. So there are instances जहाँ पे court बता रहे कि आप public के सामने apologize करो. Then only we will feel कि this was genuine. So that is all about apology. The next remedy which we have is appeal. For appeal, we can refer section 19. Section 19 of Contempt of Courts Act says that contemner has right to appeal. An appeal shall lie as a right from any order or decision of High Court in the exercise of its jurisdiction to punish for contempt, where the order or decision is that of single bench to a bench not less than 2 judges, and then order or decision is of bench, then it will go to Supreme Court. So appeal के यहाँ पे 2 levels है. First है High Court का. High Court में अगर single judge is giving the judgment or passing the order, उनका अपील हाई कोर्ट में ही जाएगा, बट बेंच के पास नॉट लेस देन 2 जजेस. अगर ऑलरेडी बेंच का ही जजमेंट है, बेंच का ही ऑर्डर है, देन द अपील विल गो टू सुप्रीम कोर्ट, provided that where the order or decision is that of court of judicial commissioner or any union territory, such appeal shall lie to Supreme Court. अगर union territory है, it will go to the Supreme Court. Pending any appeal or appellate court may order that execution of punishment or appellant is in confinement may be released on bail, or appeal be heard notwithstanding that appellant is not purged for his contempt. So appellate court के पास कौन कौन से powers relating to order, execution of punishment, or may that person be released on bail, or appeal be heard notwithstanding that the appellant is not purged for his contempt. And whenever any person aggrieved by the order against which appeal may be filed satisfies the High Court that he intends to prefer an appeal, the High Court may also exercise all or any powers conferred in subsection 2 which we have discussed previously. But there is one twist. ये जो appeal का right है, that right can be exercised only once. Only one appeal is allowed. Where an appeal is filed against an order of the learned single judge to division bench, the statutory right of appeal gets exhausted and there is no further appeal to Supreme Court. So आप एक ही बार appeal कर सकते हो. There is no thing that single judge से bench तक गया, bench से Supreme Court तक गया. No, that is not happening. It is just happening once. But there is always this remedy of 136, Article 136 of Indian Constitution, that is SLP, Special Leave Petition. So these are the remedies which are available. But there is also one more thing which I want to tell you all, that Contempt of Court Act does not provide any provision to the court for review. Appeal hai but review nahi hai. That you all must remember. Now the very important part, that is defenses. So defenses अगर देखना पड़ेगा तो we will divide it in category. Defenses for criminal contempt, defenses for civil contempt. Let's discuss criminal contempt first. As you can see it on the screen, I hope you can see the screen. Section 3, 4, 5, 6, 7 provide defenses. First, Section 3, innocent publication and distribution of matter that will not amount to contempt. A person shall not be guilty of contempt of court on the ground that he has published any matter which interferes or tends to interfere with, obstructs or tends to obstruct or scandalizes, whatever all those things, had a no reasonable ground for believing that the proceeding was pending and it is completely innocent publication. Then in that case, this person can totally use this defense. Then the next defense, that is section 4, fair and accurate report of judicial proceeding. Subject to the provision contained in section 7, a person shall not be guilty of contempt of court for publishing fair and accurate report. That's it. Then we have section 5. Section 5 talks about fair criticism. A person shall not be guilty of contempt of court for publishing any fair comment on the merits of the case, which has been heard and finally decided. So कोई matter अगर finally decided है and you are making some fair criticism about it, you are giving some commentaries about it, that's absolutely fine. That will not amount to criminal contempt. Then next is section 6. Section 6 basically talks about complaint against presiding officer of subordinate court and when it is not contempt. So a person shall not be guilty of contempt in respect of any statement made by him in good faith. Suppose you are writing any complaint or about any officer कि ये corrupt है, इसने ऐसे ऐसे किया है. So if it is genuine, then that will not amount to contempt. So you can make such statements and you can go for these statements to any subordinate court or high court. Civil contempt, just to quickly revise what is civil contempt. Civil contempt is basically willful disobedience or willful breach. तो पहला डिफेंस अपना वही है, एंड फॉर दैट वी डोंट हैव टू रेफर एनी सेक्शंस. पहला डिफेंस है दैट जो डिसोबीडियंस था, जो ब्रिज था, वो विलफुल नहीं था. For civil contempt, that the disobedience of order, decree, or the court, or the breach of any undertaking given to court was not willful. Hence, it would be a defense. Then, second defense which is available to us is that order has been passed without any jurisdiction. Hence, there was no jurisdiction. Hence, I did not follow. ऐसे वाला scenario हो सकता है. So, if the order disobeyed is proved to have been passed by the court without jurisdiction, or the undertaking violated is proved to have given in a proceeding which was without jurisdiction, the disobedience or violation would not amount to contempt of court. Actually, order passed without jurisdiction, as we all know, it is void. All those orders are void and it will bind nobody. Hence, contempt यहाँ पे नहीं रहेगा. The decree or order passed by the court will be of nullity and it has no jurisdiction with the subject matter. The next defense is order disobeyed is vague and ambiguous. अगर कोई ऑर्डर दिया गया है उसके मल्टीपल इंटरप्रिटेशन है, वेग है, which is very difficult for that person to obey, in that case you can totally use this defense and it will not amount to contempt. Vague and ambiguous orders are the defenses in contempt orders which are not specific and complete. Vague क्या होता है, which जो specific नहीं है, complete नहीं है. Then our next defense is the no knowledge of order. A person cannot be held guilty of contempt of court in infringing an order of the court which he knows nothing. अगर मुझे ये particular order pass किया गया है, I have no idea about it. There is no receipt that I have received such order or that has been communicated. In that case, you can use this as a defense. And the last defense, that is compliance with the order, is impossible. जहाँ पे बहुत ही exorbitantly amount अगर fine वगैरह दिया गया and you are not able to pay that much, it is highly impossible. You can use this as a defense. In civil contempt of court, it would be a valid defense to say that the compliance with the order of the court was impossible. Actually, impossibility plea is tested on case-to-case basis. Judge will decide, court will decide whether that was actually practicable, practically possible, and it is proved by the contemner. It is allowed as defense. It is not general. Contemner needs to prove. And then there are other defenses as well. That is act. Nothing contained in this act shall be construed as implying that other defenses which have been valid defense in any proceeding, that should be accepted. So let's quickly revise. There are defenses in criminal contempt. Criminal contempt क्या कर रहा है? Authority of the court, due process or administration of justice. यहाँ पे disturbance, scandalizing, lowering the authority, ये scenario अगर हो रहा है तो criminal contempt है. Criminal contempt के defenses क्या क्या है? Innocent publication, distribution of matter. Innocent publication and distribution of matter is not contempt. अगर आप कोई चीज पब्लिश कर रहे हो and that is fair and accurate report, that is a defense. Fair criticism is a defense. Publication of information relating to proceedings in chamber, basically it is not content but there are exceptions to. अगर secret proceeding है, security of the state है, expressly prohibited है, तो फिर ये defense नहीं applicable. And then हमारा जो section 6 है, that also talks about complaint against presiding officer, कि अगर आपको कोई issue or problem address करना है, you can always write it in write about it and that will not amount to contempt. क्रिमिनल कंटेम्प्ट के डिफेंसेस ये है. एंड सिविल के बहुत ही इजी है. दैट डिसोबीडियंस विलफुल नहीं था, जुरिस्डिक्शन नहीं था, ऑर्डर ही वेग है, नॉलेज ही नहीं है, या कंप्लायंस ही बहुत डिफिकल्ट है. So these are the very basic concepts which are there about contempt of court. There are few judgments as well which I can share with you. The first and popular judgment, State of Bihar versus Bihar MSESKK Mahasangh. There was an order of the court directing to pay salaries, and some employees were not paid as their appointments were in serious doubt. The appointment was in question. Court held that such circumstances it cannot be said that contempt was deliberate and hence not amounting to punitive action, because we can see that order को follow करना was difficult यहाँ पे. Then the next judgment which we can discuss is that Sultan Ali Nangiana versus Noor Hussain. The burden to prove that court passing the order had no jurisdiction to pass it to the proceeding in which the undertaking was given without jurisdiction, as we discussed previously. And the next case, basically in this case, the Honorable Supreme Court held that even if an order is void, it cannot be ignored by the party aggrieved by it. The party cannot decide कि order binding नहीं है. They must approach court. Suppose as हमने already देखा है that कोर्ट का अगर ऑर्डर है जो बाइंडिंग नहीं है तो आप घर पे बैठ के यू ऑन योर सेल्फ कैन नॉट डिसाइड कि ये ऑर्डर हम फॉलो नहीं करेंगे बिकॉज इट्स नॉट बाइंडिंग. यू मस्ट नोटिफाई द कोर्ट एंड सीकिंग द क्लैरिफिकेशन एंड डिक्लेरेशन फॉर इट. These were the some cases which were there for civil contempt. And there is again this Bharat Cooking Coal versus State of Bihar जहाँ पे Honorable Supreme Court clarified the legal position by holding that where the order is incomplete and ambiguous, parties shall approach the original court and get it clarified. Next, that is criminal contempt के कुछ cases. In this KK Verma versus Union of India, this case dealt with the issue of whether an article published in newspaper that criticized the judiciary amounted contempt of court. Supreme Court ने इस केस पे बताया that criticism of judicial acts can constitute contempt if it scandalizes or lowers the authority of court. The court emphasized that fair criticism, however, not contemptuous if it doesn't undermine the authority of judiciary. In the next case, MS Sahlawat versus Union of India, Supreme Court clarified that while freedom of speech is fundamental, it cannot extend to acts or statements that tend to lower and scandalizes the authority of the court. In this case, the court found that publication of defamatory article about a judge to be contemptuous as it affected the public's confidence. And the very classic and popular Arundhati Roy's case. In this case, the writer and activist during the Narmada Bachao Andolan published many articles, made public comments criticizing the judiciary. Even there were some instances जहाँ पे कोर्ट सुप्रीम कोर्ट के बाहर मोर्चा धरना with placards वगैरह हो चुका था. Supreme Court found her guilty of criminal contempt, stating that freedom of speech does not allow defaming the judiciary. This case again reinforced the importance of maintaining the dignity of the court. Then again another popular judgment, Arun Shourie versus Union of India. Arun Shourie was a journalist, was found guilty of criminal contempt after publishing statements that criticized judiciary. The court observed that even though the publication was in the form of an opinion, it had the potential to undermine the authority of the court and obstruct the course of justice. The court reaffirmed that such actions which interfere with the judicial proceedings or bring the court in dispute can lead to criminal contempt. Then R.K. Anand versus Registrar. In this case also, the Delhi High Court found that R.K. Anand, a senior advocate, guilty of criminal contempt for attempting the influence of judicial proceeding by bribing a witness. So these were the few instances, and there are so many judgments about contempt of court जहाँ पे client had submitted a will to the advocate and advocate is denying in the court that no such submission was made. This is contempt. Criticizing the judgment or telling your client that I have no faith, the judge is biased. All these instances will amount to contempt of court. So, based to summarize quickly what we have discussed what is contempt, basic dictionary meaning of contempt. Then we discussed types of contempt. There are some jurists also authors जिन्होंने contempt के definition, contempt of court का definition देने को try किया, but to conclude it, there is no concrete definition of contempt of court. And then we move to the historical part. Historical part में why we needed the Contempt of Court Act 1971 was established. Then also we talked about the kinds of contempt. After that, we also discussed what is civil contempt, what is criminal contempt, then essentials of it. Then we talked about contempt by all the bodies, lawyers, judges, corporate bodies, state, After that, we talked about the defenses, the remedies which are available, and we concluded our lecture with these points. I hope it was clear. The very basic concept of contempt of court. So with that, I would like to declare that I am done. If you have any doubts, let's discuss that. Yes, let me just check. If a party to a case makes derogatory or disparaging remarks against a sitting judge during the trial or attempts to physically harm the judge, would this amount to contempt of court under Indian law? Obviously, this will amount to contempt of court. Even there is this obligation on lawyers that they must tell their clients to behave. And as the consequences, which we can talk about it, consequences, of course, for that we need to discuss section 12 that talks about the punishment. And you all know punishment, imprisonment, or fine, or both. Any other question? You can drop that question or you can just unmute yourself and ask. So I think that's it from my end. Could you please, yes, of course, I'll share this PPT. I'll share this PPT with the coordinator. There are certain changes and corrections, to be honest. I'll complete that PPT and share that with you.
Thank you so much, ma'am. On behalf of Team Nyaya Shastra, I would like to extend our heartfelt gratitude to Ms. Sanghpriya Shere for graciously sharing her valuable time and expertise with us today. Thank you for enriching our experience, ma'am. Moving forward, now let me introduce you all Nyaya Shastra. Nyaya Shastra aims to be a key hub for promoting legal excellence through combination of research, teaching, raising awareness, and encouraging healthy competition. We are committed to advancing legal knowledge and creating community that includes legal enthusiasts, scholars, professionals, and students. Our goal is to create a dynamic environment that fosters growth, innovation, and excellence in legal field. Ultimately, we want Nyaya Shastra to be a leading platform that bridges the gap between academic and practical law, combining research, education, and awareness. With this, I would like to introduce Vidhika, a quarterly law journal. I would request my team to display the flyer for it. So this is the Vidhika. You can submit your articles and papers for the inaugural issues of Vidhika. You can send it by 15th of March. And apart from this, Nyaya Shastra also organizes various competitions such as judgment writing, legal drafting, moot court, quiz, and many more. Nyaya Shastra also includes webinar every month. With this, I would like to announce that right now Nyaya Shastra is organizing its first virtual moot court competition, which is going to be held from 27th to 29th of April. The registrations for which are open till 31st of March. For more details, you can visit our website nyayashastra.co.in and Instagram and LinkedIn pages. Also, I would like to inform that Nyaya Shastra has launched a test series for Rajasthan Judiciary Examination 2025. You can scan the QR code and you can register for the test series. And with this, I, Angika Rajshri, the host for today's program, is signing off from today's webinar. Thank you everyone from joining us, and we hope you had a valuable experience. For more valuable insights like this, you can stay connected with us through our social media handles. Thank you.